Let's unpack this high-stakes scenario. You're an Indian tech giant.
Right.
You're in Bengaluru negotiating a billion-dollar merger. And the U.S. firm insists on flying their own New York M&A lawyers over to handle it all.
On the ground in India.
Exactly. So the core question is, can they even do that? Can a foreign lawyer just practice law on Indian soil?
And that's a question that really gets to the heart of legal sovereignty.
It does. And for this deep dive, we're cutting right to the answer by looking at the landmark Supreme Court judgment, Bar Council of India versus A.K. Balaji.
A huge case.
It really settled this decades-long clash between, globalization and the Advocates Act of 1961. Our mission here is to figure out what practicing law actually means.
Especially when it's happening in a boardroom, not a courtroom.
Where did this all start?
Well, what's fascinating is how it began. As the Indian economy boomed, foreign firms wanted in. They started setting up these liaison offices.
Okay, and what were these offices supposedly doing?
They were very careful with the wording. They claimed they were only advising on foreign law or, just providing back office support.
But the Bar Council of India saw things a little differently.
Oh, absolutely. They saw it as practicing law through the back door, a way to get around enrolling as advocates and submitting to Indian rules.
So they took them to court.
Yeah.
What was the BCI's core legal argument?
It all came down to sections 29 and 33 of the Advocates Act.
Right.
Those sections basically say only advocates enrolled in India have the right to practice law here. The conflict was, well, did practice just mean litigation, showing up in court?
Or did it cover everything else? The advisory work, the contract drafting?
Exactly. And the Supreme Court came down with a very broad, very authoritative interpretation. They said the right to practice is the genus, the big category.
And the right to appear in court is just the species. It's just one specific part of it.
Precisely. So practice of law covers it all, giving legal opinions, drafting documents, advising clients, everything.
But what was the court's pressing, practical reason for that broad definition? Why so strict?
It all comes down to one word: accountability.
Mm-hmm.
If you restrict the practice of law to enrolled advocates, you subject them to the Bar Council's disciplinary jurisdiction.
So if there's professional misconduct, there's a body that can hold them accountable.
Exactly. Imagine an unregulated foreign lawyer messes up a high-stakes merger. Who does the client complain to? The ethical standards have to apply to everyone.
Sure, but the court couldn't just build a wall around the country. Legally speaking, globalization is a reality.
Right, so they had to find a balance, and that's where the exceptions come in, like the fly-in, fly-out rule.
Explain that one.
Foreign lawyers can make casual, temporary visits to India, but, and this is key, it's for specific purposes, to advise on foreign law or maybe to participate in an international commercial arbitration.
But the court put a serious limit on that.
A very serious one. They said if those visits become frequent, regular, or systematic, then it stops being casual. It becomes illegal practice.
So you can't just set up a permanent practice by buying a lot of plane tickets.
That's a perfect way to put it. And that same thinking, that scrutiny, applies to legal process outsourcing, LPOs.
Right, the LPOs. So firms claim they were just, outsourcing transcription?
Transcription, data entry, clerical work. The court applied what's called the pith and substance test.
Meaning they look past the label to see what's actually going on?
Precisely. Is the core, the true nature of the work, just secretarial? Or is it disguised legal advice and drafting?
And if it's disguised legal work?
It's prohibited. You can outsource the typing, but you can't outsource the legal mind.
So let's bring this all together. What does this mean for you? The final verdict upheld the ban on foreign firms setting up shop in India.
With those very tight, very casual exceptions we just talked about.
And so for businesses, the warning is pretty clear. If you hire foreign counsel for India-based deals, you have to be careful.
Their advice needs to stick to foreign law, and their presence has to be temporary, not systematic.
And for all the legal professionals listening, the big lesson is that the definition of practice is so much broader than just arguing in court.
It really is.
The A.K. Balaji judgment drew a clear line. Indian law is for Indian advocates. But it does leave us with a provocative question for the future, doesn't it? As global trade gets even more complex.
You have to wonder.
Do you think India might eventually have to consider opening its doors a bit wider, maybe on a strictly reciprocal basis, to meet the demands of a global market that just keeps shifting?